Um, record should reflect we've had a lengthy bench conference in this matter, and Mr. Brown brought forth the point that this case, in some form and or another, was previously adjudicated at preliminary examination in June, and the case was dismissed. When I say the case, I guess I'm talking about the factual circumstances of this case, because it was then reauthorized against this individual. This case, then this one then coming. What happened on the reauthorization is that a count was added. We had, I don't know how many attorneys up here trying to clarify what was added and the basis for it. As I'm to understand, so that the record is clear, the basis for the reauthorization was new evidence. That might be a basis to reauthorize a case if it were truly new evidence. Upon questioning by the court, the prosecutor that reauthorized it indicated that the new evidence was the body cam footage from the police agency, which existed at the time of the original case. And that I don't know under what definition of new that even falls, but that the case was previously dismissed because there was conflicting testimony as to whether or not the backpack was blue or whether it was black. They went back to look at evidence which was already in the possession of the, or available, I should say, to the people, of the color of that backpack, determined the color, and then brought this new case against this defendant. The reality is, don't care how you dice it, slice it, cut it, that's not new evidence. That's just evidence that wasn't looked at by the people at the time of the original case. And quite frankly, I probably would have had a lot more to say, but we got a lot here today. But I will tell you that I told the prosecutor, and I'll make it very clear, that is not new evidence. It shouldn't have, this case should never have been reauthorized, because it's not even really a reauthorization, because it's really a nothing. This defendant should not have been before this court on this charge, had to go through that entire process. This witness should not have had to be here. They should have just admitted to their mistake from the very beginning, just called it and said, we blew it. They've blown it. This case is previously dismissed. This one, albeit a reauthorization, this court is ordering that it is dismissed, and these charges are dismissed against this defendant given what's happened with prejudice. Sir, you may step down. Thank you.
Buckle up, guys. Today we're going to witness a courtroom moment that flips completely against the prosecution. What starts as a routine hearing quickly turns into a sharp judicial takedown. As the judge reviews the case history, he realizes the so-called new evidence was actually available from the start. Frustrated by what he sees as a serious failure, he makes it clear this defendant should never have been back in court at all.
Case of the people of the state of Michigan versus Jeremy Shue.
Al Chemlowski for the people.
Good morning, Your Honor. Jay Kill on behalf of Jeremy Shue. Jeremy, would you state your name for the record?
Jeremy Shue.
Thank you.
Your Honor, today we adjourned one of the R&O charges against Mr. Shue because we didn't have a medical. I'm not sure we still don't have the medical, but that being said, in the interim, Mr. Shue wrote a 2-page letter to me basically saying that I should be disbarred. He refused to see me at the jail. So obviously there's been a breakdown in attorney-client privilege. He has every right to be represented by an attorney. He obviously doesn't want me. I'll leave it in the court's discretion. I'm asking to be withdrawn.
That's me, sir.
Go ahead, Jeremy.
Your Honor, Mr. Killaw was substituted by Mr. Rushhour due to a one, Mr. Killaw.
What do you mean substituted by?
Judge, there were 4 traffic offenses I was also pointed on with Judge Freshour. And in my conversations with Mr. Shu, I filed a motion for Judge Freshour to recuse himself, which apparently didn't sit well with Mr. Shu.
Again, I'm sorry,
No, I just had to get clear what you were telling me because I didn't know.
I was trying to tell you, but Mr. Kilgore cut in.
Well, no, I asked him, Jeremy, to explain it to me. So,
No, what I was gonna tell Your Honor was Judge Freshour, substituted Mr. Kilgore for Mr. or Bob Elman. However, due to Mr. Kilgore not coming to see me, I still haven't got no medical records from the prosecutor, which that's a violation.
well, hold on, Jeremy. You're jumping ahead because what I understand is they don't have them.
They don't have it.
Yeah, it's not like, hold on. Got to quit being so suspicious, right? If the prosecutor had given them to Mr. Kilowall, there's not a doubt in my mind he would have gotten them to you because that's what we've been waiting. So you're jumping ahead. You're getting suspicious like somebody's trying to withhold something or denying you your rights. If it's not there, that may work to your advantage. But, well, now you understand, but you were about to go off on something. So, yes, you were. Go ahead.
Okay. Mr. Kilowall filed a motion without my knowledge or without my input to Judge Freshour that was perjured, saying that I filed legal action against Your Honor. Ms. Freshour didn't really care for that when I explained to her that Mr. Kilowall, I have documents.
Hold on. You got to slow down because I'm not there. So you got to explain it to me. Okay. So Mr. Kilowall files a motion. What was it? A motion to recuse?
Correct.
And saying that you had filed something against Judge Freshour, like a grievance or something?
No, it was legal action against Judge. As of yet, I haven't pursued the last domestic violence that was falsely charged as of today. There's also other great.
Well, hold on, just hold it. So you're saying that Mr. Kilowald made some statement that was false in that motion? Okay. And the statement you're saying is what?
That I filed legal action against Judge Freshour, which as of today, I have not.
Okay, but you were anticipating that you might do that.
Yes, I am.
Okay.
Prosecution.
Okay, all right, I got you. Okay, so let me just stop you there, and I know you got more to tell me. If Mr. Kilowald knew that you were contemplating it, then him making that statement would be a proper statement to make to the court. Okay. So again, I think you're jumping ahead saying he's filing something that's perjurious or whatever, but he would, and in fact would be protecting your right by doing that. Okay. All right. Go ahead with your next part of your conspiracy.
Due to as of to date, we haven't had no discovery in either of these matters. As of to date, we haven't got the or not the police report, but the camera. What the other Scott versus Harris were entitled to have the camera.
And Jeremy, you're going to start quoting law to me now.
I'm sorry, sir. I'm
Jeremy, how long have we been dealing with each other?
long time, sir.
Yeah. You think I know the law?
Yes, I.
Okay, but go ahead. I'll let you talk.
The other thing is, in the domestic violence allegation that was falsely charged and rightfully dismissed, it was Prosecutor Jessica Blanche made a comment stating that I would not be charged with these R&Os had I completed a treatment program in that domestic violence case. The domestic violence was ultimately dismissed. The probation violations was ultimately dismissed. So that threat for vindictive prosecution raises another issue, which we need to transfer from that domestic to show that it's blanket. if Mr. Kilowog would have bothered me.
Well, but hold it, Jeremy.
I understand I'm getting ahead of myself.
Yeah, you are. So you're saying that the prosecutor made a statement that if you completed some type of batter's intervention or domestic violence program.
It was a dual diagnosis program in Saginaw, which due to my
Yeah.
wheelchair and all that stuff, I wasn't allowed to attend that program. And Judge Conlon ultimately dismissed the probation violations.
Okay.
Due to the 18 violation of the program itself.
Right.
As of now, I sat in jail. I was out there doing what I needed to do. I was threatened by the prosecutor and falsely charged domestic, where I did 4 months for a misdemeanor. The domestic was dismissed. The witness intimidation was brought up, ultimately dismissed.
Okay, Jeremy, I'm going to stop you again. All of that may have happened. I'm not understanding what that has to do with what's before me.
I understand, sir. It plays into the vindictive prosecution of this case that we're setting here. And now in the police report, they state that there was medical records. However, one of the reasons Mr. Kilwall, our communications had broke down is because he gave me with the prosecution knowledge and coming from the prosecution office, gave him, obviously, he gave me personal information, Sergeant Victim, of the last time we were here. When I brought it up to Mr. Kilwall, that he gave me the address, the phone number, the social security number, the driver's license number, and everything. He told me to hang on to it.
At this point, the hearing takes a dramatic turn as Jeremy accuses his own attorney of mishandling sensitive information and possibly putting him at risk. The judge lets him speak, listens carefully, and then firmly steps in. From the bench, he pushes back against Jeremy's assumptions and makes it crystal clear that he trusts his attorney completely. The tension rises as the judge directly challenges Jeremy's growing suspicion.
He basically blew me off.
Judge, I got to stop right here. There's no way I told this gentleman to hang on to that stuff, okay? And I've been listening to him patiently. I tried to see him a couple times. He refused to see me. The one time he did, it lasted 30 seconds. He turned his wheelchair around, said, "You're fired." So he can talk all he wants.
Anyways, he gave me documentation. I had to bring that documentation up to a sergeant at the jail on camera and give him that documentation because I felt that I was being set up for another witness intimidation case, which the officers involved in these matters, I have no hostility towards. I don't have no ill will towards. I don't mean them or their families any harm. I'm not a violent person. I was outside of jail doing what I needed to do. I had that information. It was like, how did this information get from the prosecutor, Mr. Kilowog, to me?
Okay, all right. So Jeremy, hang on a second. Let me assume for the sake of argument that what you're saying is true. Okay? Let's say the prosecutor turned this over to Mr. Kilowog. Mr. Kilowog gives it to you. Let's just, for the sake of argument, I don't know that it happened that way. I don't think necessarily it would. You say something to Mr. Kilowog. Mr. Kilowog goes, "Well, just hang on." Okay? That's what you're telling me. So the conclusion, hold on. The conclusion you jump to is that Mr. Kilowog is some part of some conspiracy to do that to you, right?
Yes,
Okay. Mr. Jeremy. I'm going to tell you you're wrong. Absolutely wrong. I've known Mr. Kilowog 25, 30 years. He's a good attorney. He's a great attorney if you just listen to him. All right? There is no way ever that he would ever do something Prosecutor, let alone anybody else, that is going to forsake his client. It would never happen. And that's why and Jeremy, I'm telling you, the conclusion that you're coming to is the wrong conclusion. Because with that man, that will never happen.
Understand but from the actions that I'm.
Hold on, Jeremy, but you're jumping to a lot of conclusions about a lot of stuff. All right. And I'm just telling you, and Jeremy, as long as we've been dealing with each other, I tell it to you straight. If I thought Mr. Kilowatt might do something like that, I'd say, okay, well, whatever. But I'm telling you, he'd never do that. Ever. He does. Okay, but Jeremy, what if you say something to him, he misunderstands what you're telling him and says, just hold on to it?
That could have been possible.
Okay, then Jeremy, I'm saying if that's possible, quit jumping to the negative. I'm telling you, jumping to the negative with this man here is just wrong. So Jeremy, what do you want me to do? Because my understanding is we were waiting on medical on this case. Right. And so maybe, Jeremy, if you talk to your attorney, maybe there's something else that's going to happen.
I'm willing to use like to hold off on this. I'm willing to speak. It hasn't came up.
Okay, but Jeremy.
Sorry.
Jeremy, maybe he hasn't come to see you because you don't act right. Jeremy, don't even try with me because sometimes, even though you're on my docket, I don't want to see you. Okay? So now, Jeremy, I'll ask you this. Do you want me to hold the motion that Mr. Kilowald has raised in abeyance, send you back, give you an opportunity to talk with him, and talk with him?
Yes, sir. I will do that.
Okay. Jeremy, when I say talk to him, what do you think I mean by that?
No talk.
Wow. Well, you actually learned something today. All right. If you if you don't understand something, don't jump to the negative like you did with everything you just told me here. Just if you don't understand something, ask the man. Just okay. And you don't listen to that either, do you? No, you don't. Don't even. You started trying to talk, and you know what the answer to that is. You don't listen. So here's what I'm going to do. I'm going to pass this matter. They're going to take you back. They're going to get you out. I'm going to hold Mr. Kilowatt's motion in abeyance. You're going to talk to Mr. Kilowatt. Jeremy, you're going to talk to Mr. Kilowatt. You're going to listen to him. Jeremy, if I believe this man would ever lead you astray, I'd get you a new attorney. He's not going to lead you astray. He's going to give you the best advice that he can, and he will fight for you.
What follows is a judge trying to pull Jeremy back from the edge before the case goes any further. Jeremy continues talking over key points, but the judge refuses to let the moment spiral. He breaks things down in plain terms, telling Jeremy that not every misunderstanding is a betrayal. Then comes a turning point. Instead of forcing a rushed decision, the judge pauses everything and gives Jeremy one final chance to actually listen.
Got it? All right, we'll call you back up in a bit. Court recalls the case, people of the state of Michigan versus Jeremy Shue.
Good morning, I'm Rob Jacob on behalf of Mr. Shue. Jeremy, would you state your name for the record? Judge, Mr. Shue, he and I have had a nice conversation.
We're shocked.
Well, he's promised to let me see him at the jail. There's been an offer made on partial offer made. We have to confirm if there's going to be a second or a complete offer made. That all being said, can we adjourn this till the 17th?
That good with you?
Yeah, yes, sir. I'm I'm playing. You keep playing with me.
I'm playing with you. What do you mean I'm playing with you?
No, I understand. I'm being sarcastic.
Okay.
That's great.
And he's gonna let me see him at the jail, and we're gonna talk about it, and hopefully we'll have this matter resolved when we come on the 17th.
Sure.
It's amazing when you just take time and talk with somebody. I tell you, he's not going to let you down.
Don't promise too much, Judge.
No, you ain't going to let him down. I know if something bad happens, it's not because he didn't try.
His name ain't Brian Lennon or Jeffrey Pfeiffer.
Well, and maybe that's good.
Right. Okay, so.
17 in person.
Okay.
Jeremy, we'll see you then. All right. Take care.
Your wisdom is correct, at least for today.
Excuse me?
Thank you very much.
My wisdom is long lasting.
I hope so. I may be calling you from the jail. All right, thank you.
Take care, Mr. Pillowall.
When the case is called back, the tone in the courtroom feels completely different. After a private conversation, Jeremy and his attorney return sounding calmer and more cooperative. The lawyer confirms progress has been made and that a possible resolution may be on the table. The judge, now more relaxed, ends the hearing with humor and reassurance, turning a tense standoff into a surprisingly human ending.